In the project management plan exists the procurement management process, which ends up settling a contract in order for a project to be worked on and accomplished. However, issues may arise during the contracting phase, which can lead to negative consequences and affecting a project in a very negative way. When a contract is in place, issues may occur that may cause a break in contract, which is known as a contract breach. A contract breach is a failure to perform material obligations. When a party fails to perform their obligations under a contract's obligations, of course, are not being met. When a party is found liable for a breach of contract, a court may award the following damages: compensatory damages, which places the plaintiff in the same position as if the contract had been performed. There's two damages that fall under the compensatory damages. One is expectation damages, which is loss of the expected profit or loss contemplated by parties. The other is consequential damages, which is damages flowing from breach but not contemplated agreement. Another damage is liquidated damages, which are damages for breach specified in contract, used when calculated damages is difficult. There's also nominal damages, a small or nominal amount of damages used to signify wrongdoing, often support tort damages. Now, in order to balance a breach in contract, the court may order one of the remedies below. Specific performance: court orders compliance with contract. Rescission: undo contracts as if it never existed, return consideration. Or restitutionary damages: pay for value of good or services received. There's also a complex licensing agreement, which is when multiple companies are involved within the agreement, which in turn involve different assets being licensed and reserved rights existing. A license could be going from one company to another. Tax issues can exist, driving the complexity of the deal. Key employees resisting the licensing agreement, resulting in the agreements being put in place. In a complex licensing agreement, one must pay attention to how terms are defined, such as the term product. Though it may sound simple, the definition of such can make for a complex licensing agreement. Another item to consider is the scope of the deal. We must ask what is being licensed from one company to another. Does the product include improvements? Are there rights to sublicense a particular right? What is the territory? Worldwide, US, Canada? Is the compensation payable? These are only a few of the many things that make a licensing agreement a complex one. Now, for the procurement management contract process, there are 4 sequential procurement management contract processes. One being the planned procurement management, which is made up of performing make or buys analysis. It creates a procurement management plan, creates a procurement statement of work for each procurement. It selects a contract type for each procurement, creates the procurement documents, and determines the source of selection criteria. The next one is conduct procurement, which includes advertising, creation of the qualified seller list, a bidder conference, seller proposal, proposal review, weighting system, independent estimates, screening system, past performance history, presentations, and finally negotiations. The next step is the control procurement. Here, we'll look at what the project manager should be doing at any point in time. Also, what problems and issues to watch out for under the different contract types that might affect the management of the project. We also look at the fact that all work and legal requirements in the contract must be accomplished, however small and however seemingly unimportant. We see that the project manager must help uphold all parts of the contract, not just the project scope. The final phase is the close procurement. And this is basically when a contract is completed for the most part. However, there's also a situation when a contract is terminated before the work is completed, which also causes the closing procurement. Now, there's also the contracting process complexity, and here this exists due to the fact that change can lead to conflict. Some situations are seller will have a different company culture and different procedures that the buyer's organization. Buyer and seller have different objectives. The seller objective is to generate revenue, and the buyer's objective is to complete the work. It's not easy to see a problem on the project because the procurement work is being done in a different location. There's a greater reliance on reports to determine if a problem exists. There's a greater reliance on the relationship between the buyers and sellers, project managers to deal with issues that are not covered in the wording of the contract. Though contract complexities may exist, there are many layers coming together for a project to take place. Therefore, organizations take the time to use contracts due to it being a legal document with several purposes, such as defining roles and responsibilities, making things legally binding, mitigating or allocating risk. In conclusion, it is imperative to pay attention to what is included within a contract, to understand its complexity and the do's and don'ts specified in it, in order to avoid a contract breach, whether it be from the seller or the buyer's perspective. Thank you.